The Supreme Court is about to decide whether a child born on American soil is automatically a citizen. The ruling could land any day now, and it would touch every family in the country. In the next few minutes, I'll break down what's actually being argued in this case, how it got to the nation's highest court, what each side is saying, the history behind the law itself, and what to watch for the moment this decision drops. This case is called Trump versus Barbara, docket number 25-365. It was argued before the Supreme Court on April 1, 2026. It centers on Executive Order 14160, signed by President Trump on his first full day back in office, January 20, 2025, titled Protecting the Meaning and Value of American Citizenship. The order directs federal agencies to stop recognizing citizenship for children born in the country under two specific circumstances: when a child's mother was unlawfully present in the United States and the father was not a citizen or lawful permanent resident, or when the mother's presence was lawful but only temporary, for example, on a student, work, or tourist visa, and the father again was not a citizen or permanent resident. Here's what the court actually has to decide. The 14th Amendment says anyone born or naturalized in the United States and subject to the jurisdiction thereof is a citizen. That clause was written in 1868, after the Civil War, specifically to overturn the Dred Scott decision, which had infamously denied citizenship to Black Americans, including people who had been freed from slavery. For over a century, courts have read the clause as a near universal rule. Born here, you're a citizen, full stop. The Trump administration argues otherwise. It says the clause actually requires something more, what the government calls allegiance and domicile, meaning a parent's lawful, permanent connection to the country. Under that theory, parents who are undocumented lack the legal standing to ever establish that kind of domicile, so their children wouldn't qualify. That argument runs straight into a 128-year-old precedent: United States versus Wong Kim Ark. In 1898, the Supreme Court ruled that a man born in San Francisco to Chinese immigrant parents who weren't even eligible to become naturalized citizens under the immigration law of that era, was still a U.S. citizen by birth, regardless of his parents' status. Both sides in this case actually agree that Wong Kim Ark controls the outcome. They simply disagree about what the ruling means. The government's lawyer, Solicitor General D. John Sauer, points out that Wong Kim Ark's parents happened to be domiciled in the United States for about 20 years before his birth, and argues that detail was central to how the court decided the case. The challenger's lawyer, ACLU National Legal Director Cecilia Wang, argues domicile was simply a stipulated fact in that case, not part of the actual legal rule the court applied, and that the rest of that lengthy 19th century opinion treats domicile as something that's sufficient to show citizenship, but never necessary. It's also worth understanding how this current legal fight got to the Supreme Court in the first place. After Trump signed the order in January 2025, federal judges across the country blocked it almost immediately. Multiple separate lawsuits were filed, including one in Maryland brought on behalf of pregnant mothers and immigrant rights organizations. 3 of those district courts issued what are called universal or nationwide injunctions, meaning the block applied to everyone in the country, not just the people who had sued. The administration then asked the Supreme Court to limit those blocks strictly to the parties who'd actually filed suit. On June 27, 2025, in a separate case called Trump versus CASA, the court ruled 6-3 that federal judges generally don't have the authority to issue these nationwide injunctions under the Judiciary Act of 1789. That ruling didn't touch the citizenship question itself at all. It was purely about court procedure and the scope of judicial power, but it immediately reshaped the underlying fight. That same day, the American Civil Liberties Union, recognizing that a class action might be the better legal vehicle, filed a new lawsuit in the U.S. District Court for the District of New Hampshire on behalf of a class of children, led by a plaintiff known only by the first name Barbara. She's a Honduran citizen who remains anonymous because of fears for her safety and her family's safety. By July 10, 2025, a federal judge certified a class of born and yet-to-be-born babies who would be affected by the order, and granted a preliminary injunction blocking enforcement against that entire class while the case proceeded. The government appealed, but rather than wait for the regular appeals process to play out, It asked the Supreme Court to take the case directly, skipping the First Circuit Court of Appeals entirely. The Supreme Court agreed to do that in December 2025 and set oral argument for April 1, 2026. So what actually happened inside the courtroom that day? President Trump himself attended part of the argument, making him the first sitting president on record to sit in on Supreme Court oral arguments. He left partway through, after the Solicitor General's opening defense. Afterward, on social media, he claimed the United States is the only country in the world that allows birthright citizenship. That claim isn't accurate. More than 30 other countries have citizenship laws that closely mirror the American system, including Canada, Mexico, Brazil, and Argentina. And roughly 50 more countries offer limited versions of the same principle. Inside the courtroom, the questioning got pointed fast, and it came from justices across the ideological spectrum, not just one side of the bench. Chief Justice Roberts described part of Solicitor General Sauer's defense as quirky, saying he struggled to understand how narrow historical exceptions, like the established exception for children of foreign diplomats, logically extended to children of undocumented immigrants generally. Justice Sotomayor told Sauer directly that his position effectively amounted to asking the court to overrule Wong Kim Ark. Sauer responded that wasn't what the government was asking for. Justice Gorsuch then noted the apparent contradiction, telling Sauer he wasn't sure how much weight the government's argument could put on a precedent that seemed to cut against its own position. Justice Kavanaugh raised a historical point about the language Congress chose. He noted that the Civil Rights Act of 1866, debated by the same Congress that wrote the 14th Amendment, used different language, the phrase, "not subject to any foreign power," and asked why the framers of the amendment would have chosen different wording if they'd meant to limit citizenship the way the government argues. Kavanaugh also pushed back on Sauer's argument that the practices of other countries should inform the court's reading, saying the court interprets American law using American precedent based on American history. He pressed further on a separate technical point. Congress reenacted essentially the same citizenship language in federal statutes in both 1940 and 1952, after Wong Kim Ark was already decided, which suggests lawmakers knowingly embraced the broad reading of the clause that the precedent had already established. Justice Barrett focused heavily on the practical side of the government's theory. She asked what would happen to a newborn's citizenship status if it had to remain legally undetermined for months or years while officials sorted out a parent's domicile status case by case. Justice Jackson asked a more textual question, pointing out that the language of the 14th Amendment focuses on where a person is born, not on the immigration status of that person's parents at all. Justice Kagan was sharply skeptical of the government's reading, at one point describing it as a revisionist theory that departs from more than a century of settled precedent. There's also a separate, older precedent that came up repeatedly, Elk v. Wilkins, an 1884 case in which the court ruled that a Native American man born on a reservation wasn't a birthright citizen because reservations were treated as sovereign from the federal government at the time. The government has pointed to that case as support for the idea that the 14th Amendment always allowed for some categories of people born on U.S. soil to be excluded from automatic citizenship. The challengers respond that Elk v. Wilkins reflects a narrow, specific situation involving relations between sovereign governments, not a general principle that could be stretched to cover children of undocumented immigrants. It's also worth noting that birthright citizenship for Native Americans was separately and explicitly guaranteed by Congress through the Indian Citizenship Act of 1924, regardless of how that older case is read today. No opinion has been written yet in this case, so there are no actual dissents to report, and no final vote count exists. But based on the questioning, court watchers and legal analysts have made informed predictions, and it's important to be clear that this next part is analysis, not established fact. One detailed statistical study of the oral argument transcript, conducted by SCOTUS blog, analyzed how often each justice spoke, who they directed their questions toward, and what topics they focused on. That analysis found the data most consistent with either a 7-2 or a 6-3 outcome favoring the challengers to the executive order, with Justices Thomas and Alito viewed as the most likely dissenting votes, and Justice Barrett viewed as the probable swing vote, whose final position is genuinely difficult to predict from her questioning alone. But here's the part most people are missing. Even if the challengers win, this legal fight may not actually be fully over. ACLU attorney Wong actually offered the court two separate paths to rule in her client's favor. The first is the big constitutional argument under the 14th Amendment itself. The second is a narrower statutory argument based on the fact that Congress separately codified birthright citizenship into federal law through the Immigration and Nationality Act. Legal analysts have pointed out that if the court chooses to rule only on that narrower statutory ground, the larger constitutional question could resurface again later if a future administration tries a more narrowly tailored executive order designed to avoid the statutory problem. That's a real possibility worth watching for in the language of the opinion itself, not just who technically wins or loses, but which legal path the court actually takes to get there. This is also where the real-world stakes get sharper. Outside research groups estimate that roughly 250,000 children are born each year to parents who would have been affected by this executive order. Immigrant rights organizations have warned that without recognized citizenship anywhere, some of these children could effectively become stateless, unable to easily prove citizenship in any country. The administration has said the order isn't intended to be retroactive, meaning it would only apply to babies born after the order officially takes effect, not to people who are already citizens today. But some legal experts have raised a further concern, that the legal reasoning behind upholding this kind of order could, in theory, be used by a future administration to challenge the citizenship status of people who were already born here, even though that's explicitly not what this particular order claims to do. That concern is clearly a hypothetical raised by critics and analysts, not something any court has actually ruled on. As it stands today, nothing about birthright citizenship has changed under current law. The executive order has never actually taken effect anywhere in the country. It has been blocked continuously by court injunctions since January of 2025. A baby born in the United States today is, under current law, a U.S. citizen, full stop, regardless of where they were born in the country or their parents' immigration status. One related ruling worth a quick rewind, since it's the direct reason this case exists in its current form. Last year's Trump versus CASA decision. That 6-3 ruling didn't decide anything about citizenship itself. It limited how broadly federal judges can block a federal policy nationwide using a single lawsuit filed by individual plaintiffs. It's the reason this specific case became a class action at all. After the CASA decision closed off the quick path to a nationwide injunction, the ACLU pivoted to building a certified class action instead, which is the legal vehicle now sitting in front of the Supreme Court. The justices are expected to rule before they break for their summer recess, which typically happens in late June or early July. Most court watchers following this case expect a decision within the next several days. When the ruling lands, the opinion itself will tell us not just who technically wins the case, but which legal path the court takes to get there, constitutional or statutory. And that distinction could matter for years of future legal fights over how citizenship law gets applied. We'll have a full breakdown the moment the ruling is actually released, with the real holding, the real vote count, and the real reasoning behind it. Until then, based on everything you've just heard about how the oral argument went, do you think the court rules for the challengers, for the administration, or finds a narrower way to punt on a statutory ground instead? Drop your prediction in the comments below.